Intellectual Property Rights and Start-Ups, brought to you by Dr. Momita Das, National Center for Innovation in Distance Education, Indira Gandhi National Open University. Entrepreneurship has received a boost in India in the recent times. The Government of India has introduced several schemes, most notably the Startup India scheme, to promote innovation and entrepreneurship in the country. The youth, mainly the students of higher education institutions, are perceived to be the torchbearers of this endeavor. The first step for the student innovator towards setting up the startup is to get empowered with the necessary knowledge and skills. On the way to establish their own startup, an innovator student needs to familiarize himself with certain concepts. Intellectual property rights is one such important concept. After watching this session, you will be able to define intellectual property, list the different types of intellectual property, describe intellectual property rights, list the different types of intellectual property rights, and explain the importance of intellectual property rights for startup. What is intellectual property? Intellectual property, abbreviated as IP, is defined as an intangible property which is the creation of the human mind. The creation has to be new with an element of inventiveness to qualify as intellectual property. Intellectual property is unique as it is the result of personal innovation and creativity. Intellectual property can be a new product, such as a lady's handbag with a light fitted inside to facilitate searching of its contents, or it can be a process of weaving traditional saris. There are different types of intellectual property based on the area of creation and application. The different types include inventions, literary and artistic creations, distinctive features such as brand names, sounds, smells, color, designs, geographical indications, trade secrets, etc. Why is intellectual property important? The main goal of intellectual property is to promote innovation in the society. The creator of the intellectual property is provided certain exclusive rights by the law called the intellectual property rights. It is also abbreviated as IPR. Let us now know a little bit more about the importance of intellectual property rights. The owner of the intellectual property can assign a certain value to his intellectual property asset for its commercialization. In the case of literary and artistic works, the creator automatically gets the copyright and moral rights for his or her work. This protection gives the innovator an economic incentive as it allows her to make profit from her creation. When the rights are protected, the creator is able to commercialize the product till a fixed time, following which the creation comes into the public domain and then anyone can make use of it. Thus, the creator is economically benefited from his or her creation, and the society also gets to use a superior creation in terms of quality. The intellectual property rights system thus provides incentives to the innovators to produce new inventions and creation. During the term or period of holding the intellectual property rights, the inventor or creator can stop others from using the intellectual property without his or her permission. The intellectual property rights laws have provisions for penalizing a violator of the intellectual property rights. The intellectual property rights are of different types based on the area of creation and application. These include patents, copyrights and related rights, trademarks or service marks, industrial design rights, plant variety rights, trade secrets, geographical indications, circuit design, supplementary protection certificates, and database rights. A startup can protect its intellectual property in essentially three ways, namely patent, trademark, or copyright. Let us know a little bit more about these three types of intellectual property rights. What is a patent? A patent is a right given to an inventor for his or her invention by the government to prevent third parties who do not have his or her consent from making, using, offering to sell, selling, and importing an invention or the act of using that process for a limited period of time in exchange for the public disclosure of the invention. Invention is defined as a new product or process involving an inventive step and capable of industrial application. And an inventive step means a feature of an innovation or invention, a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art. For a product or process to be patentable, it has to be new, non-obvious, and should have the capability of industrial application. The duration of protection for patents as per the Patent Act of 1970 of India is 20 years from the date of filing the application. After the patent is granted, it is protected throughout India. What are copyright and related rights? A copyright is an exclusive right granted to the creator in the areas of original, literary, dramatic, musical, and artistic works, cinematograph films, and sound recording. For a work or film or recording to be granted a copyright, it has to be original. The copyright holder can authorize others through a license to reproduce the work in any material form, including the storing of it in any medium by electronic means. As per the Copyright Act of 1957, the duration of copyright in India is lifetime of the author until 60 years from the beginning of the calendar year next following the year in which the author dies or the film and sound recording is published. The related or neighboring rights include performers' rights and broadcast reproduction rights. When a performer appears or engages in any performance, she has special rights which are exclusive. Every broadcasting organization has a special exclusive right called the broadcast reproduction rights. The term or duration of performers' rights is for 20 years. What are trademarks or service marks? A trademark is an exclusive right given to a person, a partnership firm, association of persons, a company, a trust, or the central or state government by the government to use it in relation to the goods or services in respect of which the trademark or service mark is registered. The duration of protection for trademark or service mark is for a period of 10 years, but it may be renewed from time to time as per the Trademarks Act of 1999. Let us now know a little bit about the importance of IPR for startups. Intellectual property rights play a crucial role for startups. As you know, startups are based on intellectual property of the founder. The protection of the intellectual property provides a competitive advantage to the startup in the market. Therefore, to prevent another competitor company from copying and commercializing it, this intellectual property needs to be protected. Also, in this process of protecting it, the startup comes to know if a similar intellectual property already exists in the world or not. This process is called prior art search. Further, if the intellectual property is protected, it means the valuation of the intellectual property has been done, and this assures funding from venture capitalists in most of the cases. How should a startup protect its intellectual property rights? There are certain important steps that a startup should take for protecting its intellectual property rights. Number one, secrecy. Maintaining secrecy when the idea is under development is important because protection of intellectual property is provided based on priority. If the idea is leaked out before it is submitted for protection, it may be rejected. Number two, valuation of the intellectual property. The value of an intellectual property is determined by its ability to generate economic benefit and to exclude its competitors from the market. A startup must carry out the valuation of its intellectual property. Number three, register for intellectual property rights. After carrying out a thorough search for prior art, the intellectual property should be registered as patent or copyright or trademark or service mark as the case may be. Number four, manage intellectual property rights in the startup. The startup should have IPR policies in place in the company. It should have agreements in place such as non-disclosure agreements and agreements with employees or independent contractors. Thank you for watching this. I hope you found it useful. Please write your views in the comments section below. Keep creating